Okay, we'll get started in just a few minutes. Good morning, everybody, or good afternoon. Want to welcome my realtor family. I hope this message finds you all safe and healthy at home. And I want to thank you for joining us, the Long Island Board of Realtors Home Together Again, a discussion with LIBOR's legal counsel, Doreen Spagnola and Patrick Fife. And I'm pleasant to introduce to you folks our Chief Executive Officer, Tessa Holtz. She'll be taking us through to the next level. Tessa?
All right. Thank you, Mr. President.
LIBOR cares.
We are so excited to have 450 members joining us for today's free webinar. As a reminder, this is the 9th webinar in this series that we have been bringing to our members throughout these work from home orders. If you are just tuning in, you can find the other 8 recordings as well as today's presentation later today at lirealtor.com/COVID. And now I am very pleased to welcome back LIBOR's Corporate Counsel, Doreen Spagnuolo, and Associate Corporate Counsel, Patrick Fife.
Hi, everyone. Thanks for joining us today. I'd like to speak with you about understanding the ESD guidelines for real estate. What is included in the most recent written ESD guidelines for real estate? Real estate services are deemed essential with severe restrictions. Real estate services shall be conducted remotely for all transactions, including title searches, appraisals, inspections, permitting, recording, legal services, financial services, and other services necessary to complete a transfer for real property. A real estate service may be conducted in person only if legally necessary, in accordance with safety protocols. No brokerage office is to be open to the public. What's not included in the ESD written guidelines? There have been many differing opinions and interpretations of this ESD guidance, since specific real estate activities and questions are not covered. There's also terms that have not been defined. For example, legally necessary hasn't been defined. As a result, differing opinions have developed, causing inconsistency and some confusion. NYSAR has provided the field with answers to some frequently asked questions based on conversations NYSAR had with various governmental agencies. However, the ESD has not set forth any written guidance confirming what they told to NYSAR over the phone. The guidance is not entirely clear. There's a gray area. Therefore, each agent in consultation with their broker and each broker in consultation with their attorney must decide whether to follow the strict wording of the guidance, which states that all real estate services must be conducted remotely and only if legally necessary can a service be performed in person, or rely on what the ESD verbally told NYSAR. So let's get to some of those frequently asked questions. Can a licensee go to a vacant or unoccupied home or vacant land to view it or take photographs for a listing? NYSAR states that based on conversations with the ESD, the answer to this question is yes, as long as you have the informed consent of the seller. NYSAR advises that if the property is not vacant or unoccupied upon arrival, the licensee should stop taking photographs or videos and leave the property. NYSAR advises against the use of a third-party photographer or videographer, as they are not an essential business. Licensees or the homeowner can always take pictures or videos. Can a licensee travel to a property and unlock the door so a consumer may enter the property for an unaccompanied showing? What if the licensee unlocks the door and waits in the driveway or out in the road until the buyer leaves? The answer is no. NYSAR does not recommend that a licensee travel to the property in order to permit access to a member of the public. Any licensee choosing to travel to the property for this purpose is doing so at their own risk. Can a licensee do an in-person showing? No. All showings must be conducted virtually. NYSAR states that if the home is occupied, the licensee can only do the virtual showing if the homeowner leaves the property, since there cannot be any person-to-person contact. Can a licensee list a property and post it as unaccompanied showings only? NYSAR recommends that licensees should not be involved in coordinating an unaccompanied showing. NYSAR states that if the seller demands the buyer be permitted to view the property, the licensee should not be involved in the process. NYSAR states that a licensee can give the buyer the seller's phone number if the seller instructs the licensee to do so. Can a licensee conduct a final walkthrough with the purchaser? No. Licensees are prohibited from going to a property with their customer or client. NYSAR recommends the buyers and sellers speak with their attorneys about scheduling a final walkthrough without the licensee being physically present. The licensee may communicate with their client or customer via phone or video conferencing during the final walkthrough. Can the purchaser be present during the inspection? The answer is no. NYSAR states that ESD advised that the inspector can perform the inspection, but may only communicate with the purchaser virtually. Does the governor's new executive order requiring individuals to wear face coverings permit licensees to have in-person contact if they abide by the requirement of the executive order? No. The new EO does not lift the restrictions on in-person contact between licensees and members of the public. Now, you may have seen that NYSAR has created a COVID-19 disclosure form for its members. NYSAR has provided this form for the members to use if they so choose. The form is optional. You can choose to use it or not, but if you use the COVID-19 disclosure form, you still cannot perform in-person showings. In-person showings are prohibited. Using the disclosure form does not change that. The LIBOR Executive Committee decided not to have LIBOR co-brand the form or make it available on our documents on demand for the following reasons. The form is readily available from the NYSAR website. Each broker will have to decide whether or not to use the form. If a brokerage decides to use the form, that brokerage can co-brand their name on the form. If you decide to use the COVID-19 disclosure form, NYSAR asks that you please follow these guidelines. Each agent must have the permission of their broker before using the form. Each broker can decide to use the form, use a form the broker prepared, or not use any form. If the broker decides to use the form, the form should be presented to the seller or buyer in the same manner an agency disclosure form is presented. Licensees should have the seller or buyer sign the form, print their name next to the signature, and provide a signed copy to the seller or buyer, and retain a signed copy for the broker's file. The form may be delivered in any manner currently permitted, such as paper or electronic transmission. What does the COVID-19 disclosure form do? The COVID disclosure form notifies the seller and buyers of the risks associated with permitting an individual to enter the property or by entering another person's property. By signing the form, the seller or buyer acknowledges that by permitting such access or by accessing the property, they assume the risk of potential exposure to COVID-19. NYSAR states that licensees should explain to the seller and/or buyer that the form outlines the risks of COVID-19 exposure, and by signing the form, they're acknowledging and assuming such risk. NYSAR also advises the following regarding the COVID-19 disclosure form. In the event the seller and/or buyer is exposed to COVID-19 as a result of permitting or gaining access to a property, the form acts as a disclosure outlining the risks and having the party acknowledge that they're assuming such risk through their actions. If a licensee or a broker were named in a lawsuit alleging exposure to COVID-19 by the seller and/or buyer, or by a member of their household, the form could be used to show the seller and/or buyer were aware of the risks and assumed the risk of permitting access or gaining access to the property. What if the buyer or seller refused to sign the COVID-19 disclosure form? If the seller and/or buyer refused to sign the COVID-19 disclosure form, you should follow the same procedure when a consumer refuses to sign an agency disclosure form. If the seller and/or buyer refuse to sign the form, the agent should set forth a written declaration of the facts of the refusal and should maintain a copy for the broker's file. Okay, next, I'm going to hand it over to Patrick so he could speak to you about financial relief for realtors. Thank you.
Thanks, Doreen.
Thanks, Patrick.
So I'm going to now just touch on a couple of things that Doreen and I talked about a bit in our last presentation, and also bring you up to date on some changes for the financial relief options that are available for realtors through the SBA and also from the Department of Labor. The original CARES Act funding set aside $349 billion of loans with the Small Business Administration, the SBA. According to the SBA, it processed more than 14 years worth of loans in less than 14 days, which is a staggering total. And that funding was for the Payroll Protection Program, the PPP, and Economic Injury Disaster Loans, EIDL. Very briefly, because we've covered this before, but for those of you out there that weren't on the last presentation or haven't looked at some of the other materials we put out, the PPP offers loans of up to $10 million for businesses to maintain payroll and related benefits, interest on mortgage and other debts, leases, and utility payments. Forgiveness is available on a portion of the loan proceeds if the employers retain employees during the specified period. And you would apply for a PPP loan through an SBA approved lender. The EIDL program is a little bit different. It's run directly by the SBA, and it expands eligibility to include nonprofit organizations and other organizations. It waives personal guarantees on loans under $200,000, waives the unable to obtain credit elsewhere provisions. And the big benefit here that was touted was that it would provide organizations with immediate funding of up to $10,000, later determined to be $1,000 per employee upon application, once your eligibility was verified. So even if you didn't take the loan, provided you met the qualifications for eligibility, you could be entitled to $1,000 per employee. And that application process, again, was directly through the SBA and the sba.gov/disaster website. So what happened to the money? Well, April 3rd, PPP applications opened for certain businesses. And then by April 16th, the SBA reported funding had stopped. And if you went on the SBA website to apply for an EIDL loan as of that date, you would see that notice of lapse in appropriations that's below. Unfortunately, that notice is still up on the SBA's website, at least as I checked at about 11:15 this morning. So if you were to go to try to apply for an EIDL loan right now, that notice is still showing on the SBA website. So the good news that I'm sure many of you heard is more money is on the way. So April 24th, the president signed a bill to approve a total of $370 billion in more relief through the SBA. The PPP is supposed to receive an additional $310 billion, and the EIDL fund is supposed to receive an additional $60 billion. Monday, which was April 27th, the PPP application process reopened at 10:30 a.m. As I just mentioned, the EIDL program, although it does have this additional $60 billion in funding, the website portal has not yet opened. Doreen and I were on a webinar on Monday that Newsday had offered with SBA representatives, and they said they weren't sure if that portal was going to open up because the applications that had already been pending may exceed that second round of financing. But I haven't heard a definitive determination from the SBA on that. So I would encourage anybody who may have not yet applied for an EIDL loan to keep an eye on that website and continue checking daily, because if it opens up, you want to put that application in as soon as possible. Reports are that this round of financing may last only 4 to 6 days, which could mean by next week that money could be exhausted. And I'm sure that we'll hear the federal government talking about more funding for these programs. So NAR has put out some quick guidance for realtors on the PPP and EIDL, and it's available on their website. But the short of it is, if you've already applied for that EIDL loan, you don't need to reapply. The SBA is processing applications already in its system on a first come, first served basis. If you haven't yet applied for an EIDL, you should file on the SBA website as soon as it opens up again. Just to repeat, as of this morning, that portal still has not opened up. But if it does, you want to be first in line to file. As for the PPP loan, if you've already applied through an SBA lender but have not been approved yet, check with your lender to see if it's maintaining a queue of applications during that lapse, where you will need to reapply. I have heard that many lenders had their applications, or if your application was in, they continued to work on it during the lapse in financing, and that those applications were then ready to be submitted to SBA as soon as the money had been appropriated. But it's very important that you communicate with your lender. If you have not yet applied for a PPP loan through an SBA lender, you want to do that again as soon as possible. Have the application filled out and have your documentation ready to give to your lender. Some tips for filing your PPP application. As I mentioned, getting your documentation together. Well, what does that mean? You want to have company formation documents or details of your business's legal organization. You want to have your 2019 tax returns if they were already filed, as well as your previous 2 years if available. Payroll records. If you're an independent contractor, you want to have 1099s together. Anything to prove what you received in terms of compensation. Mortgage and rent documents, documentation of utility expenses to the extent that your application is seeking those, proof that your business is in good standing from the Department of State, documentation of how the coronavirus pandemic has negatively impacted your business. So you want to have some kind of financial statement, something showing that you have suffered economic injury as a result of the COVID pandemic. Second tip is working with the right lender. Obviously, we're not going to recommend any specific lenders, but the SBA itself publicly has said that small businesses may be better off working with small lenders. If you have an existing relationship with an SBA lender, go to that lender. And the SBA also recommends be prepared to try multiple lenders, which you can find on the SBA's website. Again, this is right from the SBA and advice that they've given to the public, but small businesses may find shorter lines and more personalized service if they work with small lenders. I know I've heard on various presentations that many Long Island businesses have had success working with some of the smaller community lenders. So again, try to have your discussions with as many lenders as possible. Now, a quick update on the pandemic unemployment assistance. Last week, the Department of Labor launched a streamlined application process. So before last week, you had to apply for traditional unemployment, wait to get denied, and then file for pandemic unemployment assistance. The process has now been changed that you can apply for the pandemic unemployment assistance without having to file for basic unemployment insurance. And Department of Labor has reported that since the pandemic began, that it's paid over $2.2 billion in benefits to 1.1 million New Yorkers. And the reason I point that out is you see a lot on social media, people complaining they haven't gotten their check yet, which may be true, but Department of Labor has started paying money out. So don't use the excuse that, well, I heard so-and-so hasn't gotten paid anything yet. As I said before in the last presentation, if you don't make the application, you won't get anything. So to the extent that you do qualify for these benefits, you should pursue them, and don't be deterred by the fact that you may have heard others have not received anything yet. According to Department of Labor, the backlog from April 8th has been reduced from 275,000 applications to just over 4,000. And the process to apply, simply go to the website below, which is the New York State Department of Labor application for benefits. Another program I wanted to touch on briefly that we haven't gone over before is the Federal Reserve Main Street Lending Program. And I'm not suggesting at this point that this may be a good option for the bulk of you, but it may be a program to keep your eye on. The Federal Reserve is going to, through banks, lend to small and medium-sized businesses that were in good financial standing before the onset of the pandemic. This is an alternative to PPP and EIDL. It's not connected to the SBA. There's no minimum company size requirements. So sole proprietors, self-employed business owners can apply. To be eligible, you need to have at least $250,000 in earnings before interest, taxes, depreciation, and amortization. Typical interest rates are 2.5 to 4%. There's a 4-year repayment term. Now, the big stumbling block on these loans, and why I said most of you may not be interested at this point, is there is a $1 million minimum loan amount. That was what Congress had provided for. However, there have been many published reports. I read some from this morning that said Congress may reduce the minimum to $50,000. I think there's been a big backlash from businesses saying, well, Main Street includes a lot of businesses that need less than $1 million. So to the extent that happens, this could be a good option for borrowing to the extent that a business would need it. The loans that businesses get through the Main Street Lending Program originate at local banks. So I think the important thing to do is speak to your local lender about your options. Communication is key. Keep your eye on as many things as possible. And this may be one thing that, to the extent you have a financial need, that it could be something available to you if you have not or are not able to get a PPP or EIDL loan. So the next topic I want to cover is planning for the eventual reopen. And there are some practical and legal considerations for licensees to take into account. First, real estate offices cannot open until the governor allows for it. I want to make it clear this discussion is not meant to tell you to go and open your businesses up. As Doreen went through, offices need to remain closed until the governor announces any change and there's new guidance from ESD. So as of now, real estate offices cannot open. But what you can do is be ahead of the curve. We've heard all about flattening the curve for COVID, but there is going to be a curve for reopening businesses, and you would want to be ahead of that curve. And the way to do that is to start planning now. One thing that you can do and you should do is, if you're a larger operation, get together some kind of task force. If you're a smaller operation, start at least you yourself planning on what you need to do. Now is the time to consider your reentry issues and develop some approaches to getting your business back up and running. And the reason I say is it's very doubtful that business will be business as usual the minute that businesses can reopen. It is likely that there will be many new requirements and restrictions from the government on the way businesses need to operate. One thing that you can do is you should coordinate with your landlord if you have one, or a property management company. Determine what restrictions, if any, there might be once they reopen. There may be restrictions on visitors, or they may have modifications to entrances, exits, and they may be making modifications to workspace. And you want to find out what modifications, if any, you might be able to make to your workspace. So some of the things you may want to start considering now: protective coverings, hygiene, and cleaning procedures. First point, protective face coverings. As you probably all know, if you're going to go out into public, as of now, based on the governor's executive order, you must wear a face covering. Essential employers right now, so to the extent that there are businesses that can open, they must currently provide face coverings for their employees. So supermarkets have to provide face coverings to their employees. There's a question right now: will this apply to all employers in the future? We don't know yet. But it is logical to think that as businesses start to become essential or deemed essential, that at least for the foreseeable future, we may need to provide face coverings to our employees. Well, you need to have them for open houses and showings. I don't know the answer to that right now, but it is something I think everyone should consider. And you may want to have at least some stockpile to begin with. I'm not suggesting going out and hoarding face coverings, but from day one, when you open up, you may need to have them. So it's at least logical to think it's something that you may want to look into purchasing to have an initial supply once you begin. Hygiene, you want to try to come up with some kinds of plans for your employees, practices to promote frequent hand washing, coughing and sneezing etiquette, proper tissue disposal, use of hand sanitizers. Again, that may come into key when you start showing houses, when you have open houses again. Cleaning procedures, review your existing procedures and consider enhancements, particularly for common areas in your own offices. Do you have a cleaning company currently? If you don't, you may want to think about making arrangements to get a cleaning company and contracted for once you begin business. There may be cleaning protocols and procedures outlined for things like showings and open houses. Again, these are things just to consider for the future, but while we are on pause, now is the time to start thinking about them and preparing. Physical changes to offices. There are no legal guidelines on this yet, but I think some of you may have seen Newsday on Sunday had an article about this. There may be a new norm for office spaces, and that would include your own office space. You may need to create barriers to separate employees who sit in close proximity to one another. There may be a need to reconfigure space. You may need to move desks and workstations to create more distance between on-site workers. And you may need to limit equipment use, prevent sharing of equipment, computers, phones, etc. So again, these are just things to think about as we hopefully get closer to reopening business. Social distancing rules. We've heard from doctors, elected officials that social distancing will probably be with us for at least some time, even after the on-pause orders are lifted. So you need to start thinking about how are you going to proceed with business if there are limits on gatherings. Will you continue to use or utilize video conferencing and virtual planned conferences for large meetings, team meetings, those sorts of things? Can you limit seating in places like meeting rooms? You may need to think about adjusting schedules, if you've got a larger office with multiple employees, multiple agents, you may need to consider having staggered shifts so that you don't have so many people arriving or working in the office at one time. And there may be guidelines for showings and open houses. you may need to think about a plan to operate business if social distancing remains the norm. Unfortunately, at this point, we don't know what those rules will be. They haven't been issued yet, but I would anticipate that we're not going to see business as usual as we move forward. One last point, and this again, it's not something that's in place, but it's being talked about, and that's employee testing and monitoring. We've all heard testing is a centerpiece for the opening up of America again. Employers may be called on to check body temperatures or require medical certification from an employee's physician if that employee is out sick. Under recent EEOC and CDC guidance, the COVID-19 pandemic does create a sufficient risk to permit widespread testing based on a direct threat standard. However, we have things like confidentiality and privacy rights and laws, as well as anti-discrimination protections. So those things would have to be considered. Again, this is not a rule yet. I'm not suggesting you need to go out once you open up and start checking your employees' temperatures, but this is something that may come up. It may be, and will certainly, if it does become a rule or requirement, I'm sure we would do a whole presentation and provide some further information on it. But the bottom line, what I want to leave everybody with is communication is the key. Make sure once you do reopen, if you have employees that have positive results or symptoms, that they know they need to stay home. You want to ensure that concerns can be elevated and dealt with effectively and efficiently. I think in whatever environment we have going forward, communication with your people in the field, with your employees, is going to be the key to success. So that's all I have on those subjects, and I think we're going to open it up to questions now.
Thank you, Patrick. Thank you, Doreen. I'm going to start off with our first question, probably to you, Doreen. When answering the questions on the pandemic unemployment insurance, should we answer yes to did your business close as a result of COVID-19? Since we are considered essential, I'm not sure if the answer to the question is yes. It seems to be only question that applies to us, and would we be eligible?
Patrick, would you want to answer that?
Sure, I can answer that. I mean, obviously it's going to be dependent upon the specific business, but NYSAR and other organizations, I think even the state has said that if you're qualified, if you're deemed an essential business, that doesn't mean that you can't seek pandemic unemployment assistance. It's really, has your business been, have you been unable to work? So the fact that you might legally be allowed to work, you're essential with restrictions. If you don't have the work coming in, you don't have new clients with listings, you don't have showings that you can make, you don't have closings that are occurring, yes, your business has been affected. It's been closed in some respect. I mean, your office is closed. Again, it's a case by case. I can't answer for one specific scenario or person, but just the fact that we are deemed essential, or real estate has been deemed essential with severe restrictions, as Doreen said, that certainly means it has an impact. And for somebody's business, yes, it may be that they are unable to work because of the practical circumstances that exist in their case.
Great, thank you, Patrick. I have another member who has, they wanted to elaborate, if they applied online for the unemployment insurance on April 8th, they have not been able to get them on the phone, as they say. I have also received a call, the member received a call 2 weeks ago that I will hear from someone within 72 hours, which they have not. Do I now also apply separately for the PUA, the Pandemic Unemployment Assistance?
I don't know what they applied for initially. I can't.
They initially applied for the unemployment insurance.
Okay.
Back on April 8th, but they have not been able to get anybody. They got a call 2 weeks ago saying they'd hear in 72 hours. Do they call them back to tell them they're denied, or do they email them, or how does that work? Maybe that'll help.
They were, my understanding is that they were supposed to initiate with the the Department of Labor was going to call the applicants. That was the process that was in place. I mean, if that hasn't happened, I would continue to try to call. I also know I don't want to throw this to all of our elected officials, but I've heard many of them at the state level say, if you're encountering really out of the ordinary situations like that, where they're telling you you're supposed to get a call in 72 hours, you haven't been communicated with, there's no harm in trying to elevate that with, let's say, your local assembly person, your state senator. Their offices have been helping individuals on a case-by-case basis at least get in touch with somebody. So that also might be an option to follow up with because they have a much more direct line with the state agencies. Yeah.
Okay. And with that being said, can they collect unemployment insurance and the PPP funds?
It's going to depend again on, well, actually, let me strike that in terms of unemployment and PPP. If you receive the PPP, that is to replace income. So you're basically, let's say you're a sole proprietor, an independent contractor, you apply for PPP, which you can, and you get it. Those funds are supposed to be used to replace income that you were not getting. It's keeping you on your own payroll effectively.
Right.
So if you're being kept on your payroll with PPP funds, then to the extent that those funds exceed what you would get for pandemic unemployment assistance, then you probably don't qualify for both. And I think, Doreen, we had heard that from SBA during that presentation on Monday.
Yeah, I'm pretty sure the SBA representative said that if you're eligible, for the PPP, then you cannot apply for the unemployment. I mean, I think he said that a few times too, but
Okay.
you really should, like Patrick said, double check because there may be something different or specific in your own circumstance that could change things. So, you should check into it further.
Yeah, I mean, I guess to the extent somebody were to get a PPP that gave them less than what they might qualify for under unemployment, there may be an opportunity. Again, I would, everybody's going to have their own individual circumstances, and they would have to consult with whether it's their financial advisor, their accountant, on their individual specific issues.
Okay. I have a member that's retired and already receiving Social Security, but continuing to work as an independent contractor. Can one still apply for any relief if they're already getting retirement, receiving Social Security?
I don't off the top of my head, I'll say have a yes, no answer to that. I think if it's replacement of income from employment, I think that should be permitted just because you have a second source of income through Social Security. It is different. But again, I don't know the specific answer to that question. So I would have to, I guess it's something we can look into and see if there is a specific answer to the general question. But logically, I would think the answer is yes, but I can't definitively give you an answer to that right now.
And I know you said it, but can you collect unemployment and PUA at the same time?
My understanding is that you unemployment and PUA.
Yes.
PPP. Yeah, it depends on the circumstance, but yes, I mean, there are plenty of people that have been able to collect both unemployment and PUA, but it's going to depend on your specific circumstances.
And one more question on that. One of the members was told they must stop unemployment immediately after receiving the PPP funds.
Well, I think that's what Doreen and I were just talking about. Yes. I mean, you think about it in buckets. If PPP is replacing that bucket of compensation or salary that you would be ordinarily getting, then you're made whole. So you can't then say, well, I'm able to still then collect unemployment. to the extent though that PPP may not be making someone whole to the level that they would get from unemployment, maybe they could continue. But I think the general guidance and what SBA has verbally said is that you shouldn't be getting both, because the whole purpose of PPP is to keep people on the payroll. So if an independent contractor, they're only one person, but they're their own payroll.
Right.
So if you're getting that PPP money to pay yourself, well, then you're really not, you shouldn't be getting a second bucket of unemployment, because that unemployment is the same thing. That's compensating you for not having that source of income. So if the source of income is coming from the PPP loan, which is fully forgivable to the extent you use it to compensate yourself, you shouldn't be getting both.
Okay. Now, if members have closings, does that affect their unemployment or PUA if they have closings?
It may. Again, it's a case by case basis in terms of that compensation when it's earned. It's all going to depend on what they got, when they got it, and what it's characterized as.
Because, in our business, you may have put something in contract 2 months ago before the pandemic, and then it closes, knock wood, closes virtually. That's a lot of folks is concerned if they're still going to be able to collect unemployment. I guess I would submit it. And I mean, what's your thought?
I think the key is documenting. I think you need to show, well, what is your ordinary, I say income, but compensation during a given period of time, and how has it now differed? Obviously, if let's say your office is closed, but maybe you're fortunate that you've had several closings and received several commission checks. Well, I would think you'd have a lot harder of a case to prove that you meet the qualifications for pandemic unemployment assistance than someone who hasn't had any closings, because either the deals fell apart, or B, they've got nobody coming in on any new deals that are closing. So I think NYSAR has, if people, I would encourage them to go to the NYSAR FAQ. There's 2 separate FAQs on NYSAR's page. The second one deals specifically with pandemic unemployment assistance, and it probably has 10 or 15, maybe even more different scenarios. And one of them does talk about commissions, and it does say it's really a case-by-case basis. So it may impact your ability to get unemployment. It may not. It's really going to depend on someone's individual circumstances.
And I just wanted to add one thing to that is, like Patrick said, you make sure you document everything, but when you're filling out the forms, make sure you include everything. Be truthful, include all of the information. If you had a closing, if you collected a commission, if you've done any work whatsoever and you haven't collected a commission, but you will be, whatever the situation may be, just include it all down so they can make an informed decision.
Gotcha.
Yeah. The struggle here is, this is a system that was never used or designed to apply to independent contractors. It was never meant to apply to realtors. So this is the first time for any of us, or for any of you, or for the state, that they've looked at this and applied it to someone who's not a traditional W-2 employee. So, I know it may be frustrating to everyone out there. It's frustrating to us that there's no black and white answers to this, but this is really, banging a square peg into a round hole. So there's no perfect answer to anybody's situation, but I think the key, Doreen hit on it, is, document your situation as best you can, and then, hope for the best in terms of getting benefits.
Thank you. And then we'll go one more, and then I'm going to jump into some showings. If you pay your income through PPP, is that then taxable?
My understanding is that it's not taxable. I think that was, and we can confirm that. But the discussion that I've heard from SBA is that it is not, but I would want to, I certainly can confirm that for everybody. Unless, Doreen,
Okay.
do you have anything on your PPP?
Yeah, I thought it was also, it was not, but I agree. Let's just make sure and we can send it out to the field.
And they can check with their accountant as well to verify that, I would imagine would be wise as well.
Yeah,
Right.
on any of these things, I mean, again, I hate to sound like a broken record, but everybody's individual circumstance is different. So on any of these applications, requests for funding, they should speak to their own accountant, financial advisor, whoever they rely upon for that specific advice.
Thank you. And now, is the PUA benefits, are those supposed to be retroactive?
I believe, yes, that they would be, that if you haven't gotten that application in, or you weren't able to, because initially, remember, a lot of people couldn't even get onto the Department of Labor system. Yeah, it would be retroactive going back to when it first negatively impacted your business.
Okay. And then one more, member received zero deposit from unemployment in my bank account. Have no answers from unemployment. Is the deposit letting me know I was processed and denied? That's a good one.
Yeah, I don't know. You'd have to speak to Department of Labor about that. I don't know what that represents. It could be that the individual didn't qualify for basic unemployment and they may still be waiting or to get a deposit for pandemic unemployment assistance.
Okay.
I can't say that is a definitive, I'd say, conclusion either way, that they didn't get it or that further benefits or some benefits may be coming down the road. Sorry, I can't. Yeah.
Okay. What do you think the chances of getting somebody from unemployment on a Zoom webinar with us would be? You don't have to
Sure, we
answer
wouldn't be the only organization asking. Look, I've heard and seen reports, whether they're on social media, but I've heard presentations. In fact, I just heard one on Monday, and this had to do with the SBA, but Congressman Swazi was on. And he said his office is helping with specific questions as to SBA. So if it's federal SBA programs, I would not hesitate to reach out to the field staff offices for your local elected representatives. If it's an issue with unemployment where, again, you're just not getting an answer, you're not getting service, that's what those offices are for. So if it's your state senator or state assembly person, they've got field offices that I know I've seen. They put out their own social media posts that say, hey, look, we're trying to help people out there. They're putting out as much information as they can. So I wouldn't hesitate in those circumstances where you're not getting an answer to going to those resources and trying them.
Okay. I'm going to jump into some showing questions. Here's one. Define member of the public. Is a client or a buyer or a customer a member of the public?
It's a really good question, because the ESD guidance has not defined a member of the public, if it's a client or a customer, but I think it's safe to assume that a client or a customer would be considered a member of the public. And I guess why you're asking the question, what's a member of the public, is whether or not you could have person-to-person contact, right? Because you keep hearing you cannot have person-to-person contact with member of the public. So I think would be safe to assume that any client or customer is considered to be a member of the public.
Okay. Thank you. I have some photographer questions. I have one. First, photographer deemed essential or non-essential?
Photographers and videographers are not deemed essential. Therefore, that's why even in the NYSAR Q&A, it says if you're planning on doing a virtual showing, it's recommended not to send a photographer or a videographer, one of those types of vendors to do the virtual showing because they're not deemed essential.
Okay. Yes, there is one if the property is unoccupied and the seller wants the professional photographer for their listing, can that be arranged with the seller's permission and the COVID disclosure without the listing agent or the seller being present in the house?
Oh, there's a bunch of questions in that one, but let me try to break it down a little bit. The licensee, you shouldn't be involved in coordinating anything that could be deemed a violation of the ESD guidelines. So if a photographer, for instance, is not an essential business, you as the licensee should not be involved in coordinating that person going to the home to conduct, to take the photographs or to conduct the virtual tour. So what was the second half of that question?
Second half was if nobody's there. Sorry, I got to scroll back up. Can it be arranged with the seller's permission and the COVID disclosure signed without the listing agent or the seller being present in the house? Basically,
Okay.
they want to send the photographer there on his own.
Right. So also, I want to point out too that COVID disclosure form does not give the licensee the permission now to go ahead and do what they're not allowed to do according to the ESD guidance. So that's a really important point. So just because you have that, it doesn't mean now you could go, go in and do in-person showings. And even still, if the house is vacant, you should not be coordinating having a photographer or vendor to go and take pictures of the house, because those photographers and the videographers are not essential. They shouldn't be working. That's not what they should be doing. So you as the licensee, you don't want to be part of coordinating a vendor to do something that is not essential, and they shouldn't be doing that type of work.
Now, I'm going to read this one, but I'm applying it to everybody, I guess. But the member asked if a family member wants to see a vacant listing, can I give him access if he follows the CDC guidelines? Now, I'm going to say family member, and then I'm going to say, how about anybody?
Yeah, you shouldn't be. You should not be coordinating any member of the public, family member, any client, customer, to go into a home to see the home. I think that was one of the Q&A questions, right, that I had mentioned before.
Yeah.
That came up all of the time. Well, what if I open the home, I open the house, it's vacant, no one's in there, I'll stay in the car, I won't be in, I won't walk through the home with the person. That's still not permissible because it's still an in-person showing.
I think we're all just hanging out with our family members too long. We want to send them to vacant properties. I have one. I have one here in reference to rental. The rental is vacant, and they have a tenant seeking immediate occupancy, and they want to rent it. What do they do? We've had this question because I know some of my colleagues, presidents upstate, have a lot of military clients that are coming back and need immediate housing. So I'm not sure. It's probably, I'm sure there's some, Suffolk being the second largest population of veterans, I'm sure we're seeing that here on the island as well. But maybe take that question as a rental. And even, if we have somebody in that case, we'll start with the rental question.
Well, real estate is essential with severe restrictions. So what does that mean? I mean, you could still have closings, you could still have rentals, right? As long as they're conducted remotely. So if the showing and everything that the licensee was involved in was conducted remotely, where the licensee was following the guidelines, and then the tenant wants to move into the home, then they could do so. Right? Did I understand that question correctly? Can the tenant move into this vacant home? As long as everything was conducted remotely by the licensee, there's no concern that the licensee was involved in something against the ESD guidelines.
Okay.
So there's nothing preventing from a home closing or a rental taking place.
Yeah, and I think that then at that point, the transfer of occupancy would really become a legal necessity because the landlord under the lease has to deliver possession to the tenant. So I think at that point, it would be safe for the tenant to take possession of the premises.
Okay. And we're still getting a lot of questions. Some folks have jumped on late. A lot of questions with the vacant properties and showing it. To my understanding, the agent can go into the house on their own, do a virtual tour for the buyer, but the buyer cannot gain access unless he sets it up with the seller. Do you want to clarify that a little bit?
Yeah, virtual showings can occur in a vacant house. So yes, this is according to conversations that NYSAR had with the ESD. If you look specifically at the ESD guidance, it says there should be no in-person services unless they're legally necessary. So what does that really mean? We don't know. The NYSAR had a conversation with the ESD and asked some of these frequently asked questions to them. And the person on the phone from ESD, and this was one of the questions, the vacant homes, told NYSAR that a licensee can go into a vacant house and do a virtual showing as long as no one is there, as long as a member of the public isn't there. They could do the virtual showing, and that's fine. The concern, however, is that the ESD has not followed up and put any of that information in writing. So that's why I had pointed out earlier in my discussion before, there's a bit of an inherent risk only to the point that the ESD has not put that in writing. Yes, they told NYSAR that the licensee can go into a vacant home to do a virtual showing, but that's why you have to have that conversation with your broker. And if you're the broker, you should have that conversation with your attorney on whether or not you want to rely on what the ESD told NYSAR, since the ESD has not put that in writing. And when you go back, the only thing we really could look at and rely on right now, as far as what the ESD told us, is what's in writing, that every real estate transaction must be conducted remotely. And if it needs to be conducted in person, it has to be legally necessary. So there's a bit of a concern because we don't know what legally necessary means, right? The ESD has not defined that. But NYSAR's Q&A states once again that a licensee can go into a vacant home as long as no member of the public is present, and the licensee can do a virtual showing because that's what the ESD told NYSAR over the phone.
And to clarify, regardless, if the seller, had folks, the seller was demanding that they want their house shown, gave the listing agent permission to go ahead and show the house, from that point, the house is vacant, or even if it's not vacant and the seller gives you in writing to go ahead and show the house they want it shown, what do you suggest that listing agent do to, one, their fiduciary duty to the seller requesting to have their house shown?
A licensee should not be involved in the coordination of a buyer and a seller getting together to view the house, because that's not remote. The licensee then could be accused of violating the ESD because they were involved in having in-person to person contact if they coordinated the buyer and the seller to get together to see the house. So a licensee should not be involved in coordinating that, making the arrangements for that at all. If the seller says, I want you to open the house, I want the buyer to go there, the licensee should decline it because they could potentially get in trouble and sanctions for violating the ESD. NYSAR, however, has put out that if a seller tells the licensee, I want you to give the buyer my phone number, the licensee can do that. That's what NYSAR said. It's not in writing anywhere. It's not included in the ESD guidance, but based on conversations that NYSAR had with the attorneys at ESD, NYSAR said a licensee can give the buyer the seller's phone number. But once again, I would like to impress the licensee should not be involved at all in coordinating the buyer to go and view the house, because that would be considered an in-person showing, a person-to-person showing.
Okay, and I can answer two virtual questions here. I'm going to just wrap them into one. The two people that could do virtual tours is one, the seller, correct?
Correct.
And the other is the agent can go there by themselves, nobody in the house coordinating that they practice, you know, all of the best practices and gloves, masks, you know, disinfectants, all that stuff. The agent can go there and do a virtual tour for their buyer.
That's what NYSAR's position is. It's not black and white. And like I had mentioned before, there's a gray area. And once again, you're going to have to speak to your attorney or to your broker in regard to what you feel comfortable doing, what if you feel like there's a risk or not in following what the NYSAR Q&As have come out. And the reason why I'm saying that is that if you look strictly at the ESD guidance, it says all real estate services must be conducted remotely. There should be no in-person services unless legally necessary. We don't know what legally necessary means. So by going to a home to show a virtual tour of the home, is that in person? There could be an argument it is. There could be an argument it isn't. So that's where the confusion comes in. That's where the gray area comes in. It's not black and white where the ESD came out with these questions and answers saying, yes, you can do this as a licensee, or no, you cannot do this. So that's why I'm saying that there's a bit of a gray area and a bit of a risk if you interpret what the writing of what that the ESD guidance specifically states. However, going back to now what NYSAR has said, they had a conversation with the attorney from ESD who said that a licensee can go into a home. If it's an occupied home, the seller must leave, and then the licensee can do a virtual showing as long as there's no one in the house, no members of the public in the house. A licensee could go to a vacant home and do a virtual showing as long as there's no member of the public, there's nobody in the house too, and as long as all safety and cleaning protocols are followed too.
Okay. Now let's break it down to, you know, we get the agent, you go in there, you do your virtual tour, buyer and seller, we put a deal together, buyer writes up an offer with their agent, never been in the house, did it virtually, seller approves the offer, we got an accepted offer going on. The next step for us is to do a home inspection. Take us to that part that buyer still hasn't been in the house, agent did a virtual tour, the seller's agent, listing agent had whatever they had online, and nobody's in the house. You know, buyer agent went in there, virtually showed it to their buyer. We agreed upon an offer. Now we're to the point in our world, we're ready to set up a home inspection. What do you recommend from that point to contract stage with buyer still not being in the house? Unfortunately, I have not sold a house completely virtual. I showed houses 2.5 months ago and finally wore everybody down and they went to contract, but I have not gone and done a virtual. I've gotten offers virtually, but nobody's gone to the bat, you know, to bat. So in our world, normally we set up the home inspection and, you know, take me from that point to contract stage.
Yeah, I mean, once again, I wish everything was so black and white that I could tell you this is exactly what you should do and this is what I recommend because this is what the ESD's position is. But I don't have that information. I have that little paragraph from the ESD. However, NYSAR did say that they spoke to the ESD and the licensee can open up a home for an inspector to go into the home. But once again, the member of the public cannot be present. So I guess what would happen if we talk this through, the home inspector would go through with the homeowner, with the licensee, with then the potential buyer, virtually go through the home and the with the inspector, and the inspector is telling the buyer what they see or what they recommend, or they can just go through the home themselves, the inspector, and then write their report and provide it to the buyer afterwards, and then have a telephone conversation with the buyer in regard to what the inspector observed. But NYSAR said that the licensee can open up the home for the inspector as long as the licensee doesn't go into the home with them and they keep their social distancing, and there's minimum person-to-person contact.
Okay, so we get the inspection done. Now we're at the point the buyer really wants to see this house before they sign a contract, or the folks that I have in the contract, they wrote they still want to do a final walkthrough, which I'm going to ask you. That's the next question. It says legally necessary. How do we approach the buyer wanting, he's good, he's about to sign a contract, inspection's great, everything's good. He just really wants to walk through that house before he signs a contract or she signs a contract?
One thing is clear, and from the guidance and also from conversations that NYSAR had with ESD, is that the licensee should not be involved in coordinating or allowing any member of the public, or in this instance, the buyer, to go to the house. So in a situation like that, where the buyer is insisting a walkthrough because they don't want to do it virtually, they're not comfortable with it, what I would say is you would have, the licensee should turn that over to the attorneys and let the seller, the buyer, let the attorneys get involved and make a decision on how that should go forward. But the licensee at that point should remove themselves from it and not allow the buyer to go into the home.
And a lot of the agents talk to the attorneys, and then the attorneys say, hopefully, let's face it, hopefully the broker has a protocol, right? The broker has a best practices by now, and they're following ESD guidelines and NYSAR recommendations. But a lot of the attorneys, don't want to deal with it, and they're just putting it back to us. At that point, would you suggest the agent give the seller and the buyer each other's phone numbers to coordinate a showing?
Now, you have to be really careful with that. As a licensee, you don't want to be accused of coordinating the buyer and the seller getting together and looking at the house. The one thing that NYSAR said that could be accomplished while removing yourself from the situation as licensee is if the seller tells the licensee, I want you to give the buyer my phone number. The licensee could do so, but that's it. You should not be involved in then setting it up, coordinating it, having a conversation on when it's going to take place, how it's going to take place, why it's going to take place. Simply, if the seller instructs you to give the buyer the seller's phone number, NYSAR's position is that, yes, you can do so. But other than that, you should be very, very careful of being accused of coordinating any in-person showing.
And I just want to clarify, in our world, we work hard, realtors work real hard. So I just want to clarify for everybody, when you're using the word remove, you still have a listing agreement. You still have a buyer's contract, whichever one you're representing. Hopefully you have a buyer's contract and you're not still thinking the seller's disclosure is your contract. But you have a listing agreement with either a buyer or a seller. That agreement is still valid. Because you're introducing these two, that's just going by the guidelines that are there. Some folks are worried about their giving up their commission because they're not involved. But we still have a legal agreement of, a licensed listing. A legal listing, whether it be buyer or seller. Is that correct?
Yeah, you could still, absolutely. You could still take the listing, right? It's still a legal contract. If you have a listing, you're still able to conduct your business. Like I think I said on the previous webinar that we did, I know you're all hardworking and so creative that you're going to come up with ways to figure out how to conduct your business virtually in the best manner that you can. And that's what I hope you all do. And I hope you all do it with the extent of reducing any potential liability of violating the ESD guidance. And that's what we're trying to help you with. And I do understand it is frustrating and a little confusing because we do not have black and white answers to tell you that you can do something or not do something. But you definitely, if you could still take listings, you could still have closings, as long as these things are conducted virtually, you could still, to the extent that you can still move forward with your business.
Okay. And now we get that done. We get the inspection done. Here we are at contract stage. Buyer signs contracts virtually, sends them back to the seller. Seller signs, we begin the fun. We've got a fully executed contract and we're on appraisal. I just got a text actually here about appraisal. They're doing desktop appraisals. Rarely in the deals that I've put together I've had one appraisal, one access to the house. They're still deemed essential, correct? Appraisals.
Ooh.
Yo,
Well, here we go.
Another topic,
I'm playing devil's advocate here.
No, that's fine. And I just, it's frustrating because I want to have black and white answers for you. That's also subject to interpretation. There's nothing in the ESD guidance that lists appraisals as being essential. However, NYSAR does have on their Q&As that appraisers are an essential business, as are inspections. And there could be an interpretation of that because of certain financial services that have been deemed essential. You can tie into or link appraisals into that. So according to NYSAR's guidance or their Q&A, they do say that appraisers and inspections are deemed essential.
Okay. All right. So I get my appraisal done. We're dancing in the streets, or we're still in our pajamas here dancing at home. I am wearing a suit, by the way. So we're at the time for final walkthrough. We've got our cleared to close. Banks and attorneys are all on board. We got a closing date set. How do we handle our final walkthrough?
Well, once again, leave that up to the attorneys to coordinate. At this point in time, the licensee should remove themselves from coordinating any walkthrough between the buyer, with the buyer, or any contact between the buyer and the seller. Let the buyer and seller speak to their attorneys and figure out how that will take place. But you have to worry about being in violation of the ESD order. So you do not want to be accused of coordinating a walkthrough with the buyer. So
well, let me give you an instance here. I have an 88-year-old attorney, a salty dog, as we call it. He is not technologically savvy, works by phone call, doesn't have a cell phone, just has an answering machine. So when you call him, he calls back, says, I don't handle the walkthrough, pretty much oblivious to what's going on in the world. And now the other attorney said, Matt, you're going to have to coordinate this because I have a closing on Friday and we're trying to, get through this. And I certainly don't want to put myself in harm's way because I am staying at home. I am adhering to best practices and I have my own standards. I'm not putting myself or any of my family members at harm. So where do you suppose do we then, and I'm merely asking because this is my first time in a national pandemic. But where do you suggest we go from there to get this answered, to find out the best practice for our walkthrough? Should we not have two attorneys that want to coordinate this and they're throwing it back on the brokers?
Well, Matt, then the agent who is going to get involved and then coordinating the walkthrough has to be aware of what the risk could be. And the risk could be an accusation of being in violation of the ESD guideline for coordinating a person-to-person contact. Unless we have something clear from the ESD stating otherwise, it's a risk that you have to decide whether or not you're willing to take. I mean, I don't know how else really to answer that because we do not have answers. And specifically, NYSAR hasn't received an answer either. NYSAR is the one who's been in contact with the attorneys from ESD. And even after having the different conversations in regard to all of these issues and questions that are coming up from our members, NYSAR even states that the licensee should not be involved in coordinating the walkthrough. So other than that, there's no other guidance. There's no other guidance, executive order, legal thing that I could look at to tell you what to do at this point. So you have to determine that right now that would be considered a violation of the ESD order right now. And you have to, speak to your attorney, your personal attorney, speak to the broker and decide what risks you're willing to take or not.
All right, so we're looking for brokers to set up their best practices, practicing. And guys, this has been such a great webinar. I know we're gonna have all of these slides available for our members. I know we're going to. I will say that I've been asked to sit on the New York State Association of Realtors PAG to get us set up for questions and answers to the governor, to getting us launched and getting back to work after May 15th. So I'll be bringing some more information. I have that Zoom call at 2 o'clock today. So, I'm doing my best to get all these answers for our members. I'm going to ask a lot of questions from our state people. I want to thank you both for all of your time and being there for our members. Really appreciate it. And, we're going to continue the fight to get us information and bring it to our membership. We want our membership to know that LIBOR cares. We care about your family first. We care about you, our members, and we care about your business. We're doing our best to get the information. I'm a practicing broker. I have no other way of making money other than selling houses. So I want to know that, I feel the pain of you, our members, because I'm going through the same thing. And, this being trapped indoors is not Matt Arnold's specialty. So Doreen and Patrick, I want to thank you for your time. Ms. Tessa, I want to thank you and staff for putting this all together for our members. And, we're going to do this again.
Thank you so much,
Thank you, everyone.
for joining us.
All right, guys, be safe, stay healthy, and look forward to seeing you out there someday soon. Bye-bye now.